Welcome everyone to this Privacy Rules Privacy Espresso. Today I'm here with Volker Wodianka from the German law firm Wodianka Legal based in Hamburg. And Volker is a great expert in privacy and data protection. And today we are going to speak about the FAQs that were released by the German Data Protection Authority, where of course they address the compliance of such platform and tools and the usage of them. And we will extend a bit more also to other service providers similar to Microsoft 365. So without further delay, Volker, I would like to turn it over to you. And my first question would be exactly what was the DPA saying in the FAQs about Microsoft 365?
Yes, thank you, Alessandro. It's interesting that we see more and more support from the authorities in terms of how to handle the transatlantic data transfers, especially in terms of Microsoft, because it's a tool that many companies and also the public sector uses. First of all, we see like development in terms of what kind of measures do they recommend. When we read at the beginning of the Schrems 2 case, topics like please use encryption method that National Security Agency cannot breach. Many people thought that's impossible. They go more now on a risk-based approach. And still, I think it's important, and that's what they reference. Please make sure to check whether it can be also an on-premise version or it's a cloud version, because with cloud, of course, there comes a lot of more management effort and ongoing measures also after signing that contract than when you have a on-premise solution. But cloud is the future, and so they make up the mind, first of all, on that topic. Another big recommendation, of course, is how to handle the question of telemetry data or telemetric data transfers. So data that is more or less flowing in the background of the system. And they recommend that you actually can work on that data flow in terms of configuration, and you can cut that telemetric data flow. Still, and that is also a fact and a learning that we have, the normal users are, let's say, non-technical competent users that just want to book the cloud application would need support in doing that. But technically, also the authorities say it's possible and you should do that. In terms of contracts, of course, use EU standard contractual clauses, the new ones, of course, and make sure that you have the latest version. I mean, an authority would never provide a users a GDPR compliant contract. It's still up to the users of the application to check the contract or let it check by a lawyer or so. But still, that's an absolute need what to do. And then again, things like trying to use pseudonymized data, for instance, functional email accounts rather than personal email accounts, and anonymization as it's possible, encryption. These are the recommendations from the authorities.
Perfect, Volker. Thanks a lot for this brief overview. And my next question is, in this case, the authority was speaking about Microsoft 365.
Yes.
But, there are other providers that are very similar to it. So how much of these extends also to these other providers?
I think most of these recommendations do apply also to other providers in the cloud sector. When we talk about hyperscalers, we see providers like AWS, Amazon Web Service, Google Cloud Solutions, and actually there have also been public discussions also in my place in Hamburg, Germany, where the Hamburg Data Protection Authority had a podium talk with AWS on the compliance of their cloud solution. And it was pretty much interesting that at least AWS says they are willing to also create individual technical and organizational solutions for the needs of the clients. And what is also pretty much obvious that data protection authorities don't know what the companies actually do while using the application. So the question is always, what kind of personal data do you process for what kind of purpose? What are your erasure periods and so forth? And the authorities don't know anything about that because we don't have a notification or approval process between the company and the authorities. And they do recommend always that companies do an internal risk assessment. That's the most important recommendation also from my side, that companies do a transfer impact assessment, DPA, balancing risks and mitigating those risks with the right technical and organizational measures. Very important message that also AWS answered in a way that they see that as a relevant factor is, again, encryption. And what is seen as the most appreciated version of encryption from the authorities' point of view is bring your own key, so that the provider itself does not hold the key, but the user holds the key. And that, together with a proper up-to-date contract, statements on FISA, of course. No, that's what I can say also from my daily work with my clients, that when they ask the provider, did you ever receive a disclosure request from an authority? Do you think you fall under the FISA Act? Yes or no? Documenting those questions and also the answers, of course, is also part of the risk documentation, and that all pays in to lowering really down the risk of being incompliant, because cloud is a risk topic. It's not black and white, and as much information you collect together with a provider on the use of the software and the framework in the specific countries. Never forget, not only hosting, but also backup and maintenance and these kind of areas where a location can be relevant. If you tick all these boxes, I think it's possible to book also Google or Amazon Web Service, but it's work, no? It needs to be managed.
And that's exactly the point. And thanks a lot for this, Volker, because it's extremely interesting to hear how these become daily work, also a big amount of work.
Yes, I mean, there are, of course, tools to facilitate this documentation work, software solutions to do a TIA or DPA, but there are also good templates from organizations and where you document your risk and the mitigating measures. Remember that this case with MailChimp, where the Bavarian authority did not talk about it's not allowed to use MailChimp, but they had concerns that the company that uses MailChimp did not have the risk assessment in place. There you understand how authorities work. They ask for documentation, and because they don't know anything about your data processing, so they would like to discuss things with you on the basis of a good documented risk assessment, and then you're far away from really heavy risks. It's just about then being in a discussion with an authority.
Absolutely. And in a broader sense, where do you see possible solution also to simplify things at government level and companies level?
Being a privacy advisor, of course, for me, it's relevant what tools are on the horizon and what developments can we see right now or in the near future. In the near future, we have, let's say, two topics. My view is the organizational side or the documentation side, the transatlantic data privacy framework. So the follow-up agreement between EU and US on data transfer, following up the Privacy Shield. So this is now in October that we have announced to be released. I expected that in January. Sounds like it would be released before, and that is, whether we like it or we don't like it, it's the follow-up tool of the Privacy Shield. And when that is really in place, it's of course good news for companies that say, yes, we work with a provider that would again self-certify. I think that's the process again to this framework. Then we have an adequate data protection situation in the US. So that's where I recommend to have a look at. On the more technical side, there are interesting developments in sovereign cloud solutions. So sovereign cloud is used in the sense of, together with a local European provider, in this case T-Systems, they promise that there is no possible access from a US provider going through to T-Systems, because T-Systems is a German company. And they kind of use T-Systems in a way like a trust center, that by separating those companies, the hosting company with the contractor company, that there's no access by public national security authorities, which is a big concern, of course, in this Schrems 2 case. And I think that's an interesting solution. We saw that already in the past from Microsoft. They also had one of these solutions, but someday it was gone. So I'm looking forward to see more of these offers. Yeah.
Perfect. Thanks a lot, Volker, and we are running out of our time. So thanks to all our followers for being with us, and I look forward to meet you all in our next Privacy Espresso. Bye, everyone.